Madam President.
Right. All right, we have two cases here involving the same defendant, both styled State of Ohio versus Jeffrey Allen Boisel. Case number 20 CR 93 and 20 CR 192. Present on behalf of the state are the prosecuting attorney Annie Collins and assistant prosecutor Adam King. Present on behalf of defendants attorney Lee Armentrout. And are you Jeffrey Allen Boisel?
Yes, Your Honor.
All right, Mr. Boisel is charged in 20 CR 93 with breaking and entering, theft, and possessing criminal tools, and 192 with failure to appear. The cases are set for trial. September 23rd. I've been presented, Mr. Boisel, with plea of guilty form in each of these cases, which indicate that you are going to withdraw your plea guilty to certain charges looks like one count in 2093 and then the indictment is 20 and 192. Now these are 3-page forms the prosecutor's office has prepared. It has your name and case number on it. On page 3, there are signature lines. And at the top, near the top of that page, there's a sentence that says, I entered this plea voluntarily. And right below that, there's a signature line, a line with a signature pen below that. And I'm looking here, and that looks like a scribble that's worthy of a doctor's signature. Is that your signature I'm seeing?
Yes, Your Honor.
Okay. All right. There's an attorney here we just talked about a minute ago, Chambers, Lady Wilson, Charles L. Wilson Jr., whose signature was 3 loops. So you kind of remind me of that and bring back memories. So, okay. Mr. Boisel, did you go over these 2 agreements with your attorney before you signed them?
Yes, Your Honor.
When did you sign them?
Just now. Yes.
Okay. Did he explain those to you and go over with you before you signed them?
Yes, he did.
And is this something you had been discussing, thinking about before today?
Yes, Your Honor.
When you came down here today before this hearing, did you expect this is something that could happen?
Yes, Your Honor.
Think you had enough time to fully consider this matter or make a decision?
Yes, Your Honor.
Do you feel that you've been rushed or pushed in any way into doing this?
No, Your Honor.
Right? Are you entering into the agreement to plead guilty in each of these 2 cases voluntarily?
Yes, Your Honor.
Now, the agreement states on page 1 in 2019 CR 193 that you're going to withdraw your plea of not guilty, plead guilty to breaking and entering under 2911.13a, provided there will be a 5th-degree felony. Further states that you understand that the possible maximum penalty for that could be 12 months in prison. The minimum would be 6. There's a possible fine of $2,500. In 192, you're pleading guilty to the charge of failure to appear under 2937.99. That's the only charge in that indictment. A 4th-degree felony. And it states that you understand that the maximum prison term for that offense would be 18 months. The minimum would be 6 months if a prison term imposed, and a fine of up to $5,000. You understand that?
Yes, Your Honor.
Now, under the law, if you are convicted of both of these offenses and sentenced to prison, the sentences to be ordered to be served consecutively, meaning one after the other. So that means that there would be potential maximum prison for these term of these 2 cases of 30 months, 12 plus 18, and $7,500. Do you understand that?
Yes, Your Honor.
Now, I know you're currently serving a prison term. So if you're convicted of this and sentenced to prison, in all likelihood that sentence will be ordered to be served consecutively. And again, that means after whatever term it is you're serving now. Do you understand that?
Yes, Your Honor.
Now, other than the term you're currently serving, and these charges here, are you facing any felony charges anywhere else?
Yes, Your Honor.
Where's that?
Madison County, Logan County.
Okay, so if you are convicted in the future of any additional charges, those sentences would also be served or be served consecutively to this charge, this sentence in this case as well. You understand that?
I do.
All right, now, are you on probation, community control, parole, or post-release control for any felony offense?
No.
Okay. Now, under the law, if you are convicted of these offenses and sentenced to prison, once you complete prison term imposed by the court, the law provides that the adult parole board has a decision or the option to decide if they want to put you under post-release control supervision for up to 3 months or up to 3 years. What that means is that you'll be supervised by a parole officer for the terms they set because the court has no involvement in that process. And if they determine while you're under the supervision that you have violated those conditions, they can return you to prison and make you serve an additional period beyond that you've already served as ordered by the court, or up to 9 months for one violation with a maximum of half of your prison term for all violations. But if you commit a new felony while under post-release control supervision, then an additional ever sentence a judge in a new case can impose upon you. That judge can also sentence you, in this case, to an additional period of 1 year, whatever time is left on the 3 years of post-release control, whichever is greater. And if that occurs, that has to be served consecutively with the sentence into the case. You understand that?
Yes, Your Honor.
Now, under the law, these are not mandatory prison offenses, so I don't have to sentence someone convicted of these offenses to prison. I propose what's called community control probation, and that means that instead of going to prison, you can put under the supervision of a probation officer at the term set by the court for a period of up to 5 years. If during that period of time that you were being supervised, probation felt that you were not in compliance, they would have to file a written notice of that to the court, serve a copy upon you. You would be entitled to have a hearing, be represented by an attorney. If the outcome of the hearing was that you failed to comply, then at that time, the court would revoke your community control, sentence you to the maximum of 12 months, and fine you $2,500 in the 93 case with breaking and entering, and in the 192 case with failure to appear, 18 months and $95,000 for all that to be served consecutively. You understand that?
Yes, Your Honor.
Right now, 20 CR 93, the indictment alleges that on or about January 31, 2020 in this county, you did by force, stealth, deception, trespass in the building at 11070 SR 506, Iron County occupied structure with purpose to commit therein a theft offense. It's defined in ORC section 2913.01 or a felony. That would be a violation of 2911.13a, breaking and entering 53 felony with a possible punishment of 6 to 12 months and fine of $2,500. Now, the indictment in 20 CR 192 alleges on or about August 12, 2020 in this county, you recklessly failed to appear in Howard County Company's Court case number 20 CR 93 after having been released pursuant to ORC 2937.29 and released was in connection with the charge of felony violation section 2937.99 in the Right Code. That's a failure to appear charge. All right, now, Mr. Boysel, do you understand what it is you're charged with in each of those indictments or charges, and what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
Do you understand the possible penalties for each offense?
Yes, Your Honor.
Now, have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, possible defenses you can try to raise in the case, and possible outcomes of a trial in each case with your attorney?
Yes, Your Honor. Are
you satisfied with his advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Have any threats been made to get you to plead guilty here today?
No, sir.
Okay, now I'm going to read on the middle part of middle of page 2 of each case, there are several lines that are printed in bold underline that spell out the substantive terms of this agreement. So I'll read what in 20 CR 93 first, and it reads, Finish on enter pleaded guilty to count 1, state dismissed remaining counts, state defense joint to recommend 9 months incarceration, seconded to the sentence imposed in 20 CR 192, and agrees to make restitution to Marshall Mini Mart in the amount of $1,260.02. In 20 CR 192, the other line is bold language on page 2. Reads, defendant shall plead guilty to the indictment, state defense joint to recommend 9 months incarceration, consecutive to the sentence imposed in case number 20 CR 93. Val, is that your understanding of the agreement in each case?
Yes, Your Honor.
Has anyone promised you anything other than that gets you to plead guilty here today?
No, Your Honor.
Under the law, Mr. Boysel, the matter of sentencing is up to the judge, not to the parties. And so although the parties make a recommendation, and there's an agreement as to what that recommendation will be from both sides, the judge is not obligated to follow that. So if you plead guilty, once I've heard all the information presented, if I decide that that's not the appropriate sentence in these cases, I could sentence you to a greater number of up to 18 months for the failure to appear and up to 12 months for the breaking in. You understand that?
Yes, sir.
Now, Mr. Boysel, do you hold any license or certificate from any state agency or a commission for any kind of a profession or occupation?
No, sir.
Right, now, you have certain constitutional rights, you must understand in both cases before I can accept a guilty plea from you. First of all, you have a right in each case to counsel. Mr. Armstrong was appointed to represent you now. That wasn't simply for the purpose of working the case out, but to provide any defense that could be available to you under the law that you wish him to provide. So, if you decide that you don't want to plead guilty in either or both cases, then Mr. Armstrong will continue to defend you, represent you, including a trial in either case or both cases, if that's what you want. You understand that?
Yes, sir.
Right now, under the law, you have a right to a jury trial in each of these cases. And what that means is that there will be 12 people selected from a group of citizens who live in this county that are summoned for jury duty on your trial day. After the 12 are selected, the evidence will be presented, and then the jury will have to decide in each case whether the state proved your guilt by proof beyond reasonable doubt. And that verdict will have to be unanimous, meaning all 12 have to agree as to the verdict in each of the two charges. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. In that case, you would have to hold a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would be the one to hear the evidence. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond a reasonable doubt. Do you understand that?
Yes, sir.
Now, under the Constitution, in each of these cases, you have a right to confront the witnesses against you and to cross-examine them through your attorney. So what that means is, witnesses against you would have to come into this courtroom and testify in front of you and your attorney and anyone else who's present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
In the Constitution, you have a right to use the power of the court to compel or force witnesses to come to the court to testify for you, just like the state. So, if you have witnesses that you don't think are going to come in voluntarily, that your request for issues of court orders, call a subpoena, and that forces those people to come to court. Be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, sir.
Right, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence that's matter at any time in the trial. No one can ever make a testify. The prosecutor can't, the judge can't. You decide. If you decide not to testify, the fact that you did not testify cannot be used against you in either case in any way. And in fact, no one can even talk about it in the proceedings except in one situation. If you decide not to testify in either case, then the judge will instruct the jury that because that is your right, they cannot consider it for any purpose in that case. Do you understand that?
Yes, sir.
Right now, in each of these cases, you're presumed innocent until proven guilty by the state of Ohio on every element of the offense charge or proof beyond a reasonable doubt. What that means is that the burden of proof isn't on you to try to show you're not guilty simply because you've been accused. In fact, under the law, you don't have to provide any defense at all. You may, but you're not required to. But whether you do or not, burden of proof will remain upon the state to prove your guilt and prove beyond reasonable doubt in each case on every essential element of each charge, which is the highest burden of proof. And it has to be by proof beyond a reasonable doubt in each case, which is the highest standard of proof that is known under the law. Do you understand that?
Yes, sir.
All right, now originally entered a not guilty plea in these two charges. The plea of not guilty denied the allegations in the indictment, denied you committed any crime, and then exercised all those rights I just described. If you change your plea today in these two cases from not guilty to guilty, then that is the opposite of not guilty plea. Guilty plea admits the allegations in that charge and admits that they're a crime and that you committed that crime. In that plea, waives gives up all the rights that I just described for you, except the right to have an attorney. You always have a right to have an attorney, no matter what you plead. But with that exception, your plea of guilty, waives gives up the right to have a jury or a court trial. The waives gives up the right to confront the witness, issue, and cross-examine for your attorney. Waives gives up the right to empower the court, compel, force witnesses to come to court to testify for you, just like the state. Waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. Waives gives up your presumption of innocence in each case, because if you say you're guilty, the state's not required to prove that you're guilty. In each case, it also waives gives up any right to file an appeal that you think you may have had up to this point in the case. And finally, it subjects you to being sentenced immediately by the court, which is what's likely to happen if you enter pleas here today to these two charges. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes.
Now, before I go on, I didn't ask that you consulted with the victim in the first charges to the restitution and the disposition.
Yes, Your Honor, on July 22nd, 2020, we actually consulted with the victim and have approved for the plea.
And there's no dispute as to the amount of restitution?
No, Your Honor.
All right, that's acceptable. Okay. All right. Now, Mr. Boyce, do you have any questions about charges? Let's see, did I ask you, are you a U.S. citizen?
Yes, I am.
Okay, all right. Now, do you have any questions about the charges in either case?
No, Your Honor.
Do you understand?
Yes, sir.
Do you understand the penalties?
Yes, sir.
Any questions about the plea agreement?
No, Your Honor.
Do you understand?
Yes, sir.
Do you understand that the evidence report's not bound by the recommendation?
Yes, sir.
Do you have any questions about the constitutional rights that I've explained?
No.
Do you understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it will mean, and what will happen if you enter that plea here today?
Yes, I do.
Do you have any questions first?
No.
Okay, now do you understand?
Yes, I do.
Okay. Now, is there anything you'd like to speak to Mr. Armstrong about before we go any further?
No, sir.
Have any questions about anything I've explained to you here today?
No.
Then is it your decision, Mr. Boyce, to withdraw your not guilty plea, plead guilty to count 1 and 20 CR 93 and to the indictment and 20 CR 92 pursuant to the terms of the agreements that I've just gone over with you here this afternoon?
Yes.
All right, then as to the charge, count 1, which in 20 CR 93, which alleged that on or about January 31, 2020 in Highland County, Ohio, you did by force, stealth, or deception trespass in a building at 11070 State Route 506, Highland County, an unoccupied structure with purpose to commit therein a theft offense as a fine, through ORC Section 2913.01 or a felony, violation of Section 2911.13a of the Higher Rise Code, a fifth-degree felony of breaking and entering, carrying possible term of imprisonment between 6 and 12 months, and a fine of $2,500. How do you plead?
Guilty, Your Honor.
As to case number 20 CR 192, which alleges that on or about August 12, 2020 in Highland County, Ohio, you did recklessly fail to appear as required in the Highland County Common Pleas Court case number 20 CR 93 after having been released pursuant to ORC 2937.29, and release was in connection with a charge of commission of a felony, violation of Section 2937.99 of the Higher Rise Code, a fourth-degree felony carrying a possible prison term between 6 and 18 months, and a fine of $5,000. How do you plead?
Guilty, Your Honor.
Thank you. Be seated. The court finds that on this day, the open court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same, pursuant to Criminal 11 as to each case. The court finds the defendant guilty of count 1 in 20 CR 93, breaking and entering. Counts 2 and 3 are dismissed. In case number 20 CR 192, defendant's found guilty of the charge of failure to appear. And please accept it for bond. Now, inasmuch as the defendant is currently serving a prison term, there's a joint recommendation. I just glanced at the discovery, and there's quite a record there, so the court doesn't feel there's any need to order a pre-sentence investigation. And so I will proceed with sentencing for anything from the state.
Unless pertaining to the plea agreement is not.
Yes, sir.
Mr. Robert,
I would ask the court to, since Drew the term of incarceration recommended by the state, I spoke with him about, I think it was 2 weeks ago today, via video here with the court. He's had his discovery for 2 weeks, I believe. He got it that same day we mailed it to him, so he's had plenty of time to go through it. He's completely cooperative with me, never looked for any excuses or really anything. He's told me exactly what happened here. So we'd ask the court to follow the recommendation since it was both 18 months.
all right, Mr. Wiesel, anything you would like to say?
No, Your Honor.
How many numbers have you had?
This is my 5th one in Ohio.
Okay, you've had like two convictions, let's say. Here comes the discovery. And you're currently, the term you're serving now is out of Franklin County?
Yes, Your Honor.
How old are you?
40.
You know how many years you've been in prison since you've been 18?
Probably about 17.
Yeah. All right. Well, Mr. Wiesel, you have pled guilty, accept responsibility, avoid the necessity of being tried on these charges, and so the court will take that into consideration in sentencing. As the order of the court that should be and are hereby sentenced in case number 20 CR 93 to a term of 9 months of incarceration at the Correctional Reception Center in Ohio. Also ordered to make restitution to the marshal penny mark in the amount of $1,260.02, which will be paid through the victim witness escrow fund account in this county, and will pay a service fee on that. And that is a sentence that obviously you can start paying on at any time, but if you serve your entire prison term, it doesn't go away. It will continue until it's paid or you die. And if it's found that you have had the ability to pay it, you don't pay it, then you could be held in contempt and be put in jail for that in the future. Also, in order to report the cost will show the granted the execution order. According to the sheriff, we have 1 day in jail time credit for that. Case number 20 CR 192 is the order of judgment of the court that should be sentenced to a term of 9 months incarceration at the Correctional Reception Center in Ohio, and there's no jail time credit on that one, according to the sheriff's certificate. Now, these sentences are ordered to be served consecutively, meaning one after another, as well as secondly, the sentences currently being served in Franklin County, and the court finds that the offenses in these two cases, as well as in the other cases that you're serving, are obviously more one course of conduct, and one single prison term not adequately reflect the seriousness of the offenses. Case number 192 is committed while you are on bail awaiting trial under charge of 20 CR 93. Court finds that the sentences are not disproportionate to the seriousness of the offense, and one single prison term would not adequately reflect the seriousness of that conduct. And based on your criminal history, it's necessary that the second sentence be served in these cases as well as the one you're currently serving for the protection of the public. Now, on completion of the prison term in these cases, Mr. Wiesel, it is possible that the adult parole authority may, their option, push release control supervision for a period of up to 3 months. They don't have to, that's what optional means, but it's up to them, not the court. If they do, then you'll be supervised under the terms that they set. And if they determine while you're being supervised that you have failed to comply, they can return you to prison, make you serve an additional period of up to 9 months for one violation with a maximum cap of half of your prison term, so that would be 9 months as well for these cases, because that's half of the prison term, which is the cap. But if you commit a new felony while under post-release control, supervision, then in addition to whatever sentence the judge in the new case can impose upon you, that judge can also sentence you in this case to an additional period of time, 1 year, whatever time is left on that period of post-release control, committing a new felony while under post-release control in this case. And if that occurred, that would have to serve consecutively the sentence in both cases. And again, you can also repay the court costs in both cases. And if you fail to do that, then the clerk can collect that through various means, including levy on bank accounts, wages, earnings, and other assets you may have. If that doesn't collect it, then once you get out of prison, not while you're in prison, but once you complete your prison term, then the court could order you to do free service, will give you credit for each hour you work, and that would be in this county. Each hour you work would reduce your judgment by that amount until paid. All right, is there anything further from counsel? All right, you're man back in custody, Mr. Wolf. Thanks.
Mayor Coach.
Okay.
Step back to Lieutenant Brown.
Mark Ward.
I'm Brett Yard.
Okay. Case number, case number 21, CR 140, Dave, Ohio versus Mark Lewis Ward. Present for the state are the attorney and Collins, assistant prosecutor King, as the defendant, attorney Armstrong. And you are Mark L. Ward Jr.
Yes, Your Honor.
See, did you know that financial disclosure form yet?
I don't believe so. I was appointed to county court, but I've not been appointed.
We need to fill out that form. I'll go ahead and sign an entry appointing you here. Mr. Ward, has anything about your financial situation changed since you were appointed to counsel out in the municipal court on this case?
No, Your Honor.
All right, you'll need to fill out a form for us after the hearing to indicate that. So I'll take word for it and we'll find that you are entitled to appointed counsel, and I'll appoint Mr. Armstrong to represent you. All right, Mr. Ward, it looks like this case is a bind over filed on August 6th from the county court in Greenville. And it looks like you're bound over on a charge of felonious assault, which is a second degree felony, which carries a possible prison term of a minimum of between 2 and 8 years, the maximum of half of, again, of whatever the judge gives as a maximum. So, 2-year minimum, 3, an 8-year maximum would be 12. And there's also a fine available of $17,500. Now, it's 50,000. Now, your case is bound over on the 6th, and the stranger is not yet acting in your case. Under Ohio law, no person can be required before this court to face a felony charge until and unless the state has presented the case to the grand jury and the grand jury has returned an indictment, a bill of indictment. The grand jury consists of 9 people who meet, they're all from this county. They meet as needed, usually once a month or occasionally more often, to hear testimony about, presented by the prosecutor's office about alleged crimes in this county. The grand jury doesn't decide whether a person is guilty or not guilty. They simply decide whether or not there's enough evidence to believe that the charge should be required to be returned and the defendant come to court to defend against the charge. So therefore, it's not necessary that all of them agree. Only 7 of the 9 have to agree on the indictment. Now, if fewer than 7 agree, then that charge is dismissed without prejudice, meaning it could be represented within the period of statute of limitations. So, at this point, there has been no charge filed, or no bill of indictment returned by the grand jury charging you with a felony. So you're not required to be here, you're not required to face any charges at this point. Now, under the law, you can waive the right to have your case heard by a grand jury and instead agree to be prosecuted by what's called a bill of information. Now, what that means is that the bill of information is simply signed by the prosecutor. It would be the same charge that might be indicted by the grand jury, but it's only going to be considered by, it's only going to be filed by the prosecutor saying, here's what happened, the prosecutor system. And in that case, then, it's not necessary that the grand jury hear your case, because you're voluntarily free to give that up. So I do have here a waiver of prosecution by indictment and also a bill of information. So let me read the bill of information. The bill of information states that in pertinent part that on or about July 22, 2021 in Hynek's County, Ohio, under the influence of sudden passion or in a sudden fit of rage, either of which is brought on by serious provocation occasioned by Colin Tumbleson, that was reasonably sufficient to incite the said Mark Lewis Ward into using deadly force, did knowingly cause or attempt to cause physical harm to Colin Tumbleson by means of a deadly weapon or dangerous ordinance, to wit, a large knife, in violation of section 2903.12A2 ORC, which is the Higher Revised Code, aggravated assault, felony of the 4th degree. So that's the charge. And that is a different charge than the felonious assault, but you would not have to face that charge if you go forward on this charge. This is a lesser offense, the 4th degree felony, and I'll talk about that in a minute. Now, I also have been presented with a waiver prosecution by indictment as your name and case number on it. And it reads that I, Mark Lewis Ward Jr., have been informed by the court of my constitutional rights and my right to be prosecuted by way of indictment, being represented by Bill Armentrout, attorney at law of Hillsborough, Ohio, to hereby freely and voluntarily waive prosecution by indictment and agree to proceed as amended by bill of information. It was stated yesterday, 8/24/21. Immediately below that is a line with the defendant underneath it, and below that, Mr. Armentrout's signature. Is this your signature I'm looking at on this right below the date?
Yes, Your Honor.
And did you sign this yesterday?
Yes, Your Honor.
Did you have your bill of information yesterday?
Yes, Your Honor.
So you understand that by signing this, what you're saying is, I want to go ahead and be brought before the court on the charge of aggravated assault instead of waiting for the grand jury to meet to turn an indictment on possibly felonious assault or could be aggravated assault, could be some other charge. It might be appropriate. You understand that?
Yes, Your Honor.
And that's what you want to do?
Yes, Your Honor.
Okay. Now, I've been presented then with a plea of guilty form, Mr. Ward, which indicates that you're going to enter a plea of guilty to that charge. And it states that you are going to plead guilty to aggravated assault under 2903.12A2 of the Higher Revised Code, 4th degree felony. Further states that you understand that the maximum prison term for that is 18 months. The minimum would be 6 months, so the range of sentence is 6 to 18 months as opposed to the 2 to 3 or 8 to 12 could be imposed for the felonious assault. And there's a maximum fine of up to $5,000. You understand that?
Yes, Your Honor.
Now, other than this charge, Mr. Ward, are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on probation, maybe control, parole, post-release control, or a felony from any jurisdiction?
No, Your Honor.
Under the law, if you are convicted of this offense, once you complete the term imposed by the court, it's possible that the adult parole authority would exercise the option that they have under the law to require you to be under post-release control supervision once you complete the term of imprisonments imposed by the court. So that means you would be supervised under the terms they set by a parole officer because the court has nothing to do with that. And if they determine that you have failed to comply while you're under supervision, then they can return you to prison even though you served the entire term set by the court for an additional period of up to half of your prison term for one or more violations. However, if your violation was a new felony, or if you committed a new felony, I should say, while you're under post-release control supervision, then in addition to whatever sentence the judge in that new case would impose, that judge could also sentence you to an additional period for committing that crime while under supervision. In this case, the additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, Your Honor.
Right, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called non-prison or community control sanctions, meaning instead of going to prison, you'll be supervised by a parole officer and the term set by the court for a period of up to 5 years. If during that period of time the probation department thought you were non-compliant, they would have to file a written notice with the court, give you a copy. You would be entitled to have a hearing and be represented by an attorney at that hearing. And if the outcome of that hearing was that you failed to comply, then at that time the court would revoke the community control and then sentence you to prison for 18 months and fine you $5,000. Do you understand that?
Yes, Your Honor.
Right? Now, I read the bill of information to you a minute ago. You understood that?
Yes, Your Honor.
You understand what you've been charged with, what the state said you did, and when, where, and how they let you do it.
Yes, Your Honor.
And did you discuss the charge, the evidence in the case, possible legal issues in the case, possible offenses you could try to raise at trial, and possible outcome of the trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Any threats been made against you to plead guilty?
No, Your Honor.
On page 2, it states the defendant shall under plea of guilty to the bill of information. State defense jointly recommend 12 months incarceration. Has anyone made any promise to you other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, the matter of sentence is up to the judge, not to the parties. So even though there's a recommendation as to what the sentence ought to be, I'm not required to follow that. If you plead guilty, I can give you any sentence that I think is appropriate between 6 and 18 months, as well as a $5,000 fine. You understand that?
Yes, Your Honor.
Now, the state has consulted with the victim in this situation.
Yes, Your Honor, I spoke with the victim of this matter on Monday, and after we went through the facts of this matter, he agreed that an ag assault in 12 months would be an appropriate sentence and plea. Thank you.
All right. Now, Mr. Ward, do you hold any license or certification from any state agency or board for any kind of an occupation or profession?
I hold an electrician certificate.
That's from a trade association, I think, right?
Yes.
It's not a mistake.
Oh, yeah. That's right.
Okay, that's okay. A lot of people use that. I'm trying to figure out a way to answer or to ask it better, but I haven't. All right. Now, you have certain constitutional rights you have to understand before I can accept your plea of guilty. First, you have the right to have counsel. Mr. Armstrong appointed to represent you, and that wasn't simply to work the case out, but to give you any defense that might be available to you under the law that you would wish to provide. Now, so if you decide you don't want to plead guilty, he will represent you, defend you, including a trial, if that's what you want. You understand that?
Yes, Your Honor.
And under the law, you have the right to have a jury trial in this matter, in which 12 citizens that live in this county will be chosen to serve on a jury from a group of Pine County citizens summoned for jury duty under trial. After the 12 are selected, the evidence will be presented, they'll be instructed on the law, and then that jury would have to decide by unanimous verdict if all 12 have to agree on whether or not the state proves you guilty. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial, and in that case, you would have that what's called a court bench trial, meaning it would be the judge who would hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt or proved beyond a reasonable doubt. You understand that?
Yes, Your Honor.
Under the Constitution, you have a right to confront the witnesses against you and to cross-examine for your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, and your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, the purpose of which is to try to bring out evidence that helps your side of the case. You understand that?
Yes, Your Honor.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, it's your request, the court issues a court order, that's a subpoena. That forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it except one situation, and that is if there's a jury trying to don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. So, the burden of proof isn't on you to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at all. You may, but you're not required to. Whether you do or not, the burden will remain upon the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge at trial. And that is the highest burden of proof that is done under the law. You understand that?
Yes, Your Honor.
Now, originally, you entered a plea of not guilty. Not guilty plea denies, no, you haven't, sorry. You are waiting, and this is the first time you come before the court. And for the record, you did have a copy of the bill more than 24 hours before this morning, or this afternoon, right?
Yes, Your Honor.
Okay. So, under the law, you could enter a plea of not guilty. A not guilty plea denies allegations, denies you committed any crime, and it exercises or invokes all the rights that I've just described. If you plead guilty, that is the opposite of not guilty plea. Guilty plea admits the allegation in the bill of information, admits the crime, admits you're the one who committed the crime. That plea waives or gives up all of the rights I have described for you this afternoon, except your right to have an attorney. You always have a right to have an attorney, no matter what your plea is. But without exception, your plea of guilty waives, gives up the right to have a jury or a court trial. Waives, gives up the right to confront witnesses against you and to cross-examine through your attorney. Waives, gives up the right to confront witnesses. Waives, gives up the right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. Waives, gives up your privilege against self-incrimination because you're the one that's saying you're guilty, so that's what's used to find you guilty. The waive gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal that you think may have had up to this point in the case. Now, my sentence is maximum sentence, so I know the certain circumstances you can file an appeal. That would have to be filed within 30 days of the sentencing entry being filed. Do you understand all of that?
Yes, Your Honor.
And Mr. Ward, are you a U.S. citizen?
Yes, Your Honor.
All right, now, do you have any questions about the, first of all, about the waiver of indictment and the agreement to go through this with the bill of information?
No, Your Honor.
You understand that process?
Yes, Your Honor.
Do you have any questions about the charge or the possible penalties?
No, Your Honor.
You understand?
Yes, Your Honor.
Do you have any questions about the plea agreement?
No, Your Honor.
You understand?
Yes, Your Honor.
And again, you understand the court's not bound by that plea recommendation.
Yes, Your Honor.
Any questions about the constitutional rights I've explained?
No, Your Honor.
Do you understand those?
Yes, Your Honor.
Do you have any questions about the plea of guilty, what it means, or what will happen if you enter that here today?
No, Your Honor.
You understand?
Yes, Your Honor.
Is there anything you'd like to speak to Mr. Armitrout about before we go any further?
No, Your Honor.
Do you have any questions about anything that I've asked you here today?
No, Your Honor.
Then is it your decision to plead guilty to the charge of bill of information pursuant to the terms of the plea agreement that I've just gone over with you?
Yes, Your Honor.
All right, then as to the charge, which reads that on or about July 22, 2021 in Highland County, Ohio. While under the influence of sudden passion or a sudden fit of rage, neither of which is brought on by serious provocation occasioned by Colin Tomlinson, was reasonably sufficient to incite said Mark Lewis Ward Jr. to using deadly force to knowingly cause or attempt to cause physical harm to Colin Tomlinson by means of deadly weapon or dangerous ordinance to wit, large knife, in violation of section 2903.12A2 of the Ohio Revised Code, aggravated assault, felony of the fourth degree, carrying possible prison term between 6 and 18 months, and a fine of $5,000. How do you plead?
Guilty, Your Honor.
Thank you. You be seated. Court finds on this day in open court, the defendant was advised of all his constitutional rights made a knowing, intelligent, voluntary waiver of the same pursuant to Article 11. Please accept an order filed. Defendant is found guilty of the offense as set forth in the bill of information, a fourth degree felony in orders of file. All right. Given the nature of the offense and the recommendation of not pre-sentencing court, at this time, I'll go ahead and proceed with sentencing, so at this time, for anything the state would like to present.
Only was the date of Your Honor.
Does the defendant have any previous felony record?
I believe he has a 2016 General Assembly conviction. He sentenced for regular.
Right. Mr. Armstrong?
I would ask the court to follow the recommendation, sentence Mark to 12 months. It's obvious that from the time of preliminary, he asked me if I would reach out to the prosecutor to see if he could resolve this matter. He was anxious to take responsibility for it, and I did. That's how we were able to come to this speedy conclusion. We asked the court to follow the recommendation.
All right, Mr. Ward, anything you'd like to say?
No, Your Honor.
Well, Mr. Ward, the reason it's not going to assault, I understand that because of something that Mr. Paulson and Thompson have done and given you, I guess you overdosed with, and you decided to exact revenge. That kind of more or less, right?
Yes.
Okay. And so, while I can understand, being upset with that, being angry, because I know that happens a lot. Unfortunately, we have a lot of people that die as a result of that because they get one thing and they get another. Unfortunately, that's kind of a risk that people that are using drugs illicitly take. And on the other hand, though, that this is not the way to exact justice from those people that have done that to you. So, given those extenuating circumstances, I understand why the case was reduced, and I have a problem with that, and I'm going to follow the recommendation. Therefore, it's the order of the judgment of the court that you be and are hereby sentenced to the Rex Reception Center in Ohio for a period of 12 months. According to the sheriff, you were arrested on the 26th of July. Is that correct?
Yes, Your Honor.
All right, so that gives you 31 days to judge that time credit as of today. Now, upon completion of this sentence, Mr. Ward, it's possible that the Adult Parole Authority may exercise an option to put you under what's called post-release control supervision for a period of up to 3 years. They don't have to do it, but it's up. And if they do, you'll be supervised on the terms they set. And if during the time you're being supervised, which can be up to 3 years, they decide that you have failed loss with those conditions, and they can return to the prisons, make you serve an additional period of up to half of the prison term, which would be 6 months for one or more violations, and then that's the cap. But if you commit a new felony, will be under post-release control supervision, then an additional never sentence a judge with a new felony case with post-planning. The judge can sentence you to an additional period of time, in this case, for committing that offense under post-release control, 1 year, whatever, for a term of 1 year, or whatever time is left on that period of post-release control. Whichever is greater, that occurs, that has to be served consecutively in the sentencing case. You're also ordered to pay the court costs, which judge can grant execution orders. If you fail to do that, then clerk like that for various means, including government bank accounts, wages, or earnings, or other assets you may have. That doesn't collect it. Then in addition to whatever, then once you complete your term, then the court authority due community service in this county they give you credit for each hour you work in an hourly rate set by the court. Each hour you work would reduce your judgment by that amount. Okay. All right, is there anything further for counsel?
Your Honor, I think that Mr. Ward was arrested on the 24th of July, not the 26th.
Oh.
He was likely held in Greenfield maybe for a couple days.
Oh, okay. Well, reading the affidavit here, I believe that's right. 22nd was charged, claim was filed on the 23rd, and it was returned on the 24th, so yeah, we'll give you one, and then the extra 2 days. Your man, that's the one thing.
Lieutenant Brown, fill out the financial affidavit for me after this. Okay. Video McGarry. It should be ready at jail on the video conference for him. That's Mr. Armentrout's client.
Mayor Rich.
No. Can you hear me, Mr. McGarry? They need to turn on the volume there.
There we go.
Thank you. All right, this case number 21 CR 44, State of Ohio versus Drew McGarry.
Two cases, Your Honor.
And then 21 CR 106, also State of Ohio versus Drew McGarry. The state's represented by the prosecuting attorney Anthony Collins and assistant prosecutor Adam King. The Armored Trout is present in the courtroom. McGarry, he is appearing by video from the Justice Center. He's charged with failure to appear 21 CR 106 and with breaking and entering theft and 21 CR 44. It's a pre-trial, and I think we have a trial set on a fairly short time frame because of speedy trial issues. So, well, actually, we do have set for final pre-trial first, but I believe you're going to be gone.
Yes, sir.
So we'll need to reschedule that. The trial set for the 23rd. When will you be back? You'll be back following.
Actually, no, Your Honor. Looks like, because I actually haven't continued, and I haven't signed it, those. Looks like you rescheduled the final pre-trial for September 20. But then the jury trial is scheduled for September 23rd.
Okay. Well, we'll just have to leave it that way for the time being, give everybody schedule.
And,
Your Honor, I think it was only done in one case though. You haven't done it for both cases.
Well, okay, since
I can provide one motion to continue, right?
well, you have a motion to continue here? Yeah, you
I think I left off one of the case numbers for that.
Yeah. You did it on 44, you didn't do it on 106.
I had intended to do that.
All right. Actually, the assignment notice went out on the 106, and this didn't change it to the 21, and the trial's on the 8, on the 23rd today, it's still there. So, okay, yeah, that was a motion for the pre-trial, yeah, continue. Question, the trial. All right, now, is discovery complete?
It is, Your Honor.
And there any pre-trial motion?
No.
All right, and has a plea offer been provided?
I have that, Your Honor. I have not communicated that to my client yet.
Okay. All right.
We still believe this matter resolves complete, Your Honor, so that's why I'm asking to leave that date on there.
All right. We can get the matter done, we need the, all possible 14 days prior, so we'll send out any short notices. So, all right, anything further than?
No, Your Honor.
All right, Mr. McGarry, your attorney will be out to discuss the case with you and the plea offer from the state. Okay? Thank you. Thank you. Any other business?
We have one more inmate, but I don't see Mr. Kirk. No more, no, Zoom, 3 o'clock Zoom.
All right. 3 o'clock Zoom?
Yes, sir.
Okay, we're good. All right, Lacey Hensley?
Mr. Kirk is not.
Your Honor,
She fled a long time ago.
Oh. Okay, so you get taken off. Who are you?
Lacey Hensley.
Okay, Lacey Hensley.
Yeah, but she fled.
Oh. Okay. Yeah, I don't know why we have her, they didn't get her off the docket then.
Is a sentencing hearing coming up?
Yeah, her sentencing is until September 22nd, I'm sorry about that. Take these cases off. Alright, sorry about that, Ms. Henley, trip uptown for no reason. Alright, Curtis Warner. Alright, case number 20 CR 84, David Kyle versus Curtis J. Warner. President State's Prosecuting Attorney Collins, present on behalf of Defendant's Attorney Danielle Witt. Are you Curtis J. Warner?
Yes, sir.
Alright, Mr. Warner is before the court for sentencing on aggravated possession of methamphetamine and fifth-degree felony. So this is a intervention due to conviction. The defendant violated those conditions. The court and then are found guilty after hearing in order to pre-sentence investigation. And I have received that report. And the matter was set for sentencing and the defendant failed to appear. It's back in March this year, and that was arrested on the 18th of August, and so he's been in custody since that time, and now before the court for sentencing. Now, these are the parties received the summary of the pre-sentence report.
State Your Honor. Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Your Honor, Mr. Warner has violated the treatment with no prior felonies. We would ask the court to order him placed on community control based on the recommendation from probation. However, we would ask the court to order him into residential treatment at this point and not release him from jail until he enters residential treatment.
Liz?
Yes, Your Honor, and speaking with Curtis, and he is in agreement with that and feels that he needs to be placed in residential treatment at this time. I spoke with Ms. Sturgill, and she indicated that she does have a bed available at Massey House on Monday. So we just ask him to be placed in community control.
Warner, anything you'd like to say?
No, just that I've been MIA for a few months here, and I just wanted to say I was strung out. I was in a bad spot. I do got myself together. I'm working every day. You know, I'm doing better for myself. So, I mean, you know, if I could get in there residential, I mean, that would do nothing but help. I mean, I've been sober since like May, I think. Yeah, I think it's when I went to detox. I went to detox for 5 days, and I left there, and I've been sober since then. I work every day, like I said. I got a stable place to live now.
So when you didn't appear, you strung out then?
Yeah, that's
Yeah, that's been 5 months.
Yeah. So I mean, it was.
So you got clean for a few days and went out and got high again.
Yeah, that's what I said. I mean, I was strung out there for a while, and then after I got, you know, I've got myself together, you know, to an extent. I need help.
Well, back on August 10th of last year, you were supposed to go to recovery council, and they just said, no, I want to go to Creel. And then they're going back there.
Yeah. Yeah, I mean,
Now that you've been caught here, yeah, I think a great idea to go to residential treatment. It's a good idea back a year ago. So why didn't you do it then?
That's what I said. I'm not trying to justify anything. You know what I mean? It was all stupid. I should have did all this. You know, I should have kept my, head together then.
Anything else you'd like to say?
No, Your Honor.
Well, since this is your first felony offense, going to be in control. I don't that you violated the law by not showing up, I could go ahead and send you to prison. And, you know, that's probably what ought to happen. Just get it over with, because I've been working with you now for, you know, a long time, back in our early last year, and doesn't seem to be working. You're going to get one more chance to sit down. So the word court should be placed under complete control for a period of 3 years under the supervision of the probation department under the following conditions. You obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times, report when and as directed, and be truthful in all statements you make to the probation department, as well as any answers you give them about your community control conditions. You must keep in conform with your residence and place of employment at all times, may not change either without prior permission. May not leave the state of Ohio without prior written permission of the supervising officer. May not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without the prior written permission of your supervising officer. You're not permitted to purchase, possess, own, or use, or have in your control any firearm, ammunition, or dangerous ordnance, or any other weapons of any other kind. I'll also tell you that in addition to that being a condition of your control because of this conviction now, you are disqualified from owning, possessing, purchasing, using, having any firearm, ammunition, or dangerous ordnance of any type. And if you do have those, even after you get done with this case, you will be subject to being prosecuted for a felony under both federal and state law. You're not permitted to purchase, possess, use, or have in your control a controlled substance, drug abuse, or the instrument, device, or thing may be used to administer them or prepare them for administration. Unless you have a lawful prescription, and you must provide a copy back within 24 hours of receipt. You're submitted to drug testing when and as requested. You may not purchase, possess, use, or have under your control any alcoholic beverage, or may be present in places where the sold will be consumed, even if that is otherwise lawful. You are not to associate with anyone who is a co-defendant in this case, or any other person who has a criminal record, is a member of a gang or a criminal group, or any person who has in the past and could in the future unless you commit a criminal offense or to violate these conditions, unless proven right by your supervising officer. That applies to family members that may fall within that description unless you were living with them immediately before commission of this offense. Now, after the date of this order, you may not marry or establish cohabitation of a common law marriage type relationship with another person without your permission. You must report any contact law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. You can provide them with financial information records so your ability to pay any fines, fees, or costs will be reviewed. Now, if you are referred for an evaluation or assessment for any further treatment, therapy, counseling, training, or programming beyond that ordered by the court, you will submit to that. And if the evaluation or assessment recommends that you undergo additional programming, you are required to enroll in a successfully complete that. You'll be required to pay the court costs and make payment arrangements to do that. You're required to do community service at the rate of 400 hours, in the amount of 400 hours, at the rate of 20 hours per week for 20 consecutive weeks, once you've completed your residential treatment and aftercare, unless you're employed at least 20 hours a week, or you're a full-time student, or you have documentation by a physician or a prior disability finding you're physically unable to perform that service. You're required to successfully complete Massey House residential substance use disorder treatment and aftercare. You'll remain in jail until you're conveyed to the treatment facility on August, I think I said August 30th, and they will pick you up and take you there. There'll be no fine imposed, there'll be no driving suspension to be imposed. Now, by being placed on community control rather than being sentenced to prison, you're deemed consented to a search without your warrant of the person, residence, vehicles, or property owned by you, or used by you, or any other property place where you're found, which is under your control at any time by any officer of the probation department. Now, if it is alleged that you have failed to comply with any of these conditions, and that includes a treatment program, it's not a lockdown facility, so if you walk away from that, you better walk to the probation department and turn yourself in. And then they'll probably put you in jail. But if you walk away and run, that's gonna be a violation. And if you do that or commit any other significant violations, then the probation department will have to allege that and a written notice to you and provide a copy to the court. You'll be entitled to have a hearing to be represented by counsel. If the outcome of the hearing is that you did violate those conditions, then at that time the court can revoke your pleading control, then sentence you 12 months, fine you $2,500. If that occurs, when you complete prison term set by the court, the parole board does have the right under the law, they choose to exercise it, to put you under post-release control supervision for a period of up to 5 years. If they do that, you supervise the conditions they set, and if during that period of time they determine that you have failed to comply, they can return you to prison, maybe serve an additional period of up to after the prison term for one or more violations. But if you committed a felony, then in addition, whatever sentence the judge and do on the case imposed upon you, that judge is also authorized to sentence you to an additional period. In this case, 1 year, or on that 3 years of post-release control, whichever is greater. First, that must be served consecutively to the sentence in the case. You understand that? Everything?
Yes, Your Honor.
All right, anything further from counsel?
There you are.
All right, so you're granted custody.
Step back, Lieutenant Brown, please.
All right, is everybody here?
That's it, Your Honor.
Who else do you have?
Jacob Leonard here,
Leonard.
All right, Jacob Leonard.
I'm correct, Your Honor.
Okay.
jail free to go, Your Honor.
Case number 21 CR 98, David, Ohio versus Jacob Lee Leonard. Present for the state's prosecutor, assistant prosecutor came, and present for the defendant is Attorney Daniel Witt. Are you Jacob Lee Leonard?
Yes, sir.
And Mr. Leonard is charged with aggravated possession of methamphetamine. This is a pre-trial, and I believe we have a trial date set of did have it set of August 9th. Now, I've been presented with pleading guilty of an intervention form. There was a motion filed for an intervention. Now, I have a sentence or a report of information, as well as a fact from yesterday, indicated Mr. Leonard that you had not reported since July the 20th. When you came in for your interview, PSI, you left before you spoke to the officer. You tried a number of times to get in touch with you by phone, couldn't get through, left a voicemail on August 5th. You get the report, and there's no record from FRS or any other agency that you're in a treatment program. So you've never talked with Mr. Fulton about this case, have you?
Yeah, probation.
No, Mr. Fulton, the sentence officer, on Rice report. You were supposed to talk to him on the 16th and you left. I'm sorry, the 20th of July, you left. We talked to him.
Drunk. You talked to Officer Polk, you left before you talked to me. Yeah.
Oh, I'm sorry, you talked to Fulton, okay, all right. But you haven't been back since, correct? You have not been back since, right? Okay. And you're not treated either, are you? Alright, okay, well, here's what I'm gonna do. For a local bond, you're remanded in custody of the sheriff. And, Mr. Fulton will go out and talk with you, and, they can go out and assess you for treatment. Because it's clear you're not gonna do anything yourself. And, if I let you continue this to run off the ground town, you're gonna end up, being another article in the paper about a fatal overdose. So, your bond is revoked. You'll be remanded to the custody of the sheriff, held until You're assessed for treatment. And I suspect there may be a recommendation for residential treatment given what you've done so far. And then after your assessment, bond will be, let's see what it was originally, I think it's our bond. So after assessment, bail will be $2,500 plus $171 deposit prior to release. And then you can make that, you can be released. If you are, you report to probation. However, if there's a recommendation that you go into residential treatment, then you will do that as a condition of your bond. And if that occurs, I will not require the $2,500. But if it's not, or if there's not debt available, then it's going to be $2,500. And you need to learn a lesson, young man, that when I tell you to do something, you do it. And when you don't do what you're told, you don't cooperate, there are consequences. So you're going to learn that. So they'll get out to see you. If they don't get to see you for a couple of days, you'll be in jail for a couple of days. If they see you tomorrow, they find that available for you next week, you'll be in jail until then. Otherwise, they decide you only need outpatient treatment, which I'm doubtful of, then you'll be able to be released with a bond. Anything further from council?
Mayor,
Man.
my pressure on retrieve this bond.
Yeah, right there.
Step back, Lieutenant Brown, please. $2:30 is the next one, Your Honor.
Yeah. And this one's Zoom, 3 o'clock.
3 o'clock Zoom with Hill. It's Ms. Happy.
And that is 3 o'clock.
3 o'clock Hill, yes.
Or 3 o'clock. Right, that's it. That's it. All right, that's it.
Right?
Release them.
Hey, Eric, you might call out there and tell them that's it. Thank you, we're gonna pause. Yeah, he's very limited.
You'll have your-
Okay, I'll check in here. Well, we
Yeah, count ready.
got 10 more minutes.
I mean, he can have another presentation, but not ready for it.
Make sure it's. No defendant yet.
Although, yeah, I'll just step off, but we have one.
Okay, please rise.
Case number 19 CR 85, James Stable Howard, James Wright, President States, Attorney Collins, Assistant Prosecutor King, President Defendant, Attorney William Harper. Are you James L. Wright?
Yes, sir.
Wright is charged with receiving stolen property, a 4-3 felony. It's pre-trial, trial was set for the 3rd. Now, I've been presented with some documents here, Mr. Wright, which indicates that you're going to plead guilty and for being recommended to be put into the prosecution diversion program as he completed the contract and paid the necessary fee.
Yes, Your Honor.
All right. So, Mr. Wright, normally when a person pleads guilty to a felony charge in this court, they're found guilty and there's a sentence imposed. Sentences could include prison term for this offense between 6 and 18 months, could be a fine of up to $5,000, could be community control or probation, or a combination of those 3. If that happens, then that person has a felony conviction. Now, there's a provision under the law which allows a court to establish a diversion program, which the court has approved that, that's operated by the prosecutor's office. It's called the prosecutor diversion program, since they're the ones that oversee it. And they're the ones that decide who they think should be put in the program. And if you are put into that program, what that means is you plead guilty, but instead of me finding you guilty, the case is held in abeyance or stayed. What that means is it stops. And I don't make a finding that you pled guilty. Your plea goes in the file, but under the law, until you've been convicted and sentenced, you're not a convicted felon. So, if you complete the prosecutor's program, pursuant to the contract that you've signed with them, then they'll notify the court of that within a period of time, usually around a year or so, sometimes a little longer, sometimes shorter. And if they notify the court that you have completed the program, then even though you pled guilty, the charge is dismissed. And that means you're never a convicted felon. And if that happens, then I set a hearing to seal the record, just to check and make sure there's nothing else that's happened that would prevent the record from being sealed. And if, assuming that's the case, and I haven't had it happen yet in the last 4 or 5 years where it hasn't been, then the record is sealed. Then what that means is there's no longer any record of it in the courthouse or any law enforcement agencies. The records can be maintained, but they can't be released. They're sealed. Not open inspection except under certain circumstances, like if you got in trouble again, then the court, prosecutor, probation department look at it. But that's very limited. And so the advantage to you of this program is gives you the chance to avoid having a felony conviction. Now, there's a couple of, I also need to explain the downside. And that is that you don't get to go into the program, and then if you don't make it, come back and say, okay, let's go back to an actual trial. This is your last chance to do that. And so that's one reason I have to go through this explaining it too. So that's the downside. And then also the other part of that is that the diversion program is a program that the prosecutor's office determines who should be allowed to be in it. They are the ones that direct it. Now, there are conditions that will be supervised by the probation department before they perform that service. But if the prosecutor's office concludes that you have reached the agreement, it's pretty much up to them. They don't act in bad faith. They say he's not done it. We've given him enough time. We're done with him. Then they can just notify me you're out, and then come back to court, found guilty, and then there would be a sentencing hearing. So that's how that works. Now, you understand that?
Yes, sir.
Okay. Well, this agreement here is, and there's also an entry and a waiver of time because the case is not totally closed, and so it's still, even though it's active, and so that you're waiting to speak trial time as well. Have that here. And it looks like you signed this on the 28th of July.
Yes, sir.
Right.
Yes, sir.
Okay. You remember signing that time waiver?
Yes, sir.
Waiting to speak trial time. Okay. And I also have here a 3-page, or a little bit more, with a diversion program. And on the top of the page, there's a sentence that says, enter this plea voluntarily. Right below that, there's this line of signature, defense, defendant, signature there. Is that your signature also? Looks like it from there. I know it's hard to see.
Yes, sir.
Do you remember signing this document?
Yes, sir.
You signed it probably the time you signed the waiver.
Signed it today, Your Honor, but we actually went over back on July the 28th.
Oh, okay, you signed it today. Okay, all right. And so you went over this with your attorney, like he said?
Yes, sir.
Explained everything to you?
Yes, sir.
All right. You understand it's agreement to plead guilty, which means there's not going to be a trial. Then we go to the diversion program, and then, you know, if that's successful, that'll be the case will be dismissed. If that's successful, then come back for sentencing. You understand that?
Yes, sir.
Okay. Now, the agreement states that you're going to withdraw your not guilty plea, plead guilty to the charge for receiving stolen property under 2913.51 fourth degree felony. Further states you understand it's a possible prison term, a maximum of 18 months, and a minimum of 6 months. There could be a fine of $5,000. You understand that?
Yes, sir.
And you're not facing any felony charges anywhere else, are you?
No, sir.
You're not on probation, parole, community control, or post-release control for a felony?
No, sir.
Under the law, I'm giving you a worst case scenario here, but again, this is your last chance to defend against the case and go to trial. But if it didn't work out and you're terminated and it's found guilty, then at that time the court would sentence you. It wouldn't have to be prison, it could still be what's called community control. Community control means you're supervised under the probation department for a period of up to 5 years under terms that are much more strict and more of them than there is for the diversion program. The diversion program is a supervision, but it's a lower level of supervision, less strict. And that could be for up to 5 years, as I said. And then if the probation department felt that you were not complying, they would file a written notice out to the court, give you a copy, and then at that time the court would revoke your community control and then send you to prison for 18 months and fine you $5,000. Now, if that should occur, you should be sent to prison. Then the adult parole authority, once you complete the prison term, under the law, has the authority, if they decide to exercise it, as option, to put you under post-release control supervision for up to 3 years. That means you're supervised by a parole officer in the terms that the parole authority sets, because the judge is not involved with that. And if they find that you have failed to comply, they could make you go back to prison, even though you served the entire term ordered by the court, for an additional period of up to 9 months for any one violation, but there's a cap, a limit of half of whatever prison term you receive for all violations. So if it was 10 months, it would be 5 months. If it was 12 months, it would be 6 and 7. But if you commit a new felony while under post-release control supervision, then in addition to whatever penalty the judge in the new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control to an additional period of 1 year, or whatever time was left on that 3 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
All right, now the charge alleges that on or about May 7, 2019, in this county, you did receive, retain, or dispose of certain property being a motor vehicle as defined under ORC 4501.01, the property of another Alicia Halverson, and that you had knew or had reasonable cause to believe that obtained from the commission of the theft offense in violation of section 2913.51 of the Washington Code. So that's the charge of receiving stolen property, as I described earlier, with a penalty of 6 to 18 months and fine of $5,000. Now, Mr. Dryden, do you understand what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And you understand the possible penalties for the offense?
Yes, sir.
All right. Now, have you discussed the charge, the evidence in the case, possible legal issues in the case, possible defenses you can try to raise in trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Are you taking any prescription drugs?
Yes, sir.
Have any expressed that may get you to plead guilty here today?
Yes, sir.
Now, other than being recommended to the diversion program if you plead guilty and make restitution, has there been anything promised to you to get you to do this here today?
No, sir.
The amount of restitution has been established in the agreement, Mr. King.
There is, so Your Honor, we have actually not been able to make contact with the owner of the motorcycle, so no restitution.
There won't be any restitution. All right. Now, you have certain rights you have to understand before I can accept a plea of guilty from you. You have a right to have counsel. Mr. Armentrout was appointed to represent you. That wasn't simply to work the case out, but to defend you, to provide any defense that might be available to you under the law that you wish to provide. So if you decide you don't want to do this, you want to defend against the charge, he'll still represent you, including a trial if that's what you want. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this matter, Mr. Dryden, in which 12 people will be selected from a group of Highland County citizens who are summoned for jury duty on your trial date. After they are selected, the evidence will be presented that be instructed by the law, and they will decide by unanimous verdict between all 12 after agree on that verdict whether the state proves you guilty. Now, if you decided you didn't want to plead guilty, but you didn't want to have a jury trial, you can waive in writing, and that means to give up the right to have a jury trial, and in that case, you would have what's called a court or bench trial. And that means that instead of the jury hearing the evidence, the judge would apply hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved you guilty by proof beyond reasonable doubt. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Dryden, you have the right to confront witnesses against you and cross-examine them through your attorney. That means that the witnesses against you have to come into the courtroom and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, then your attorney will ask questions. That's called cross-examination, and the purpose of that would be to try to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Under the Constitution, you have the right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, your request for these court order is called a subpoena. That forces those witnesses to come to court to be able to testify if you want them to, even though they don't want to be here. This is the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, Mr. Dryden. What that means is you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can. You make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. In fact, no one's even allowed to talk about that, with one exception. If there's a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Dryden, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. So what that means is the burden of proof isn't on you to try to show you're not guilty simply because you've been indicted. Back in the law, you're not required to present any defense at trial at all. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio. Prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Right now, originally you entered a plea not guilty. That plea, not guilty, denied the allegations against you, not committed a crime, and it exercised all of the rights that I've just described. You change your plea from not guilty to guilty. That is the opposite of not guilty plea. The guilty plea admits the allegation, admits it's a crime, admits that you committed that crime, and that plea waives up all the rights I've described for you today, except the right to have an attorney, which you always have no matter what you plead. That exception, you plead guilty, would waive you up the right to have a jury or court trial, waive you up the right to confront witnesses against you, and cross-examine for your attorney, waive you up the right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. Waive you up your privilege against self-incrimination because if you say you're guilty, that's what's used to find you guilty. The way to give up your presumption of innocence because if you say you're guilty, the state's not required to prove you guilty. But also subject you to being sentenced immediately by the court. And finally, the way to give up any right to file an appeal that you think you may have had up until this point in the case. Now, if at any time you should be sentenced to the maximum sentence under certain limited circumstances, you could be an appeal filed. That would have to be filed within 30 days of your sentencing entry being filed in the case. Do you understand that?
Yes, sir.
Are you a U.S. citizen, Mr. Dryden? Are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the diversion agreement or what you'll be required to do?
I don't think so, sir.
You understand?
Yes, sir.
Have any questions about the charge and possible penalties?
No, sir.
You understand those?
I think so. Yes, sir.
Have any questions about the plea of guilty or what will happen if you enter that plea here today?
No, sir.
You understand?
Yes, sir.
You understand all the constitutional rights I've explained to you and how they'll be impacted if you plea guilty?
Yes, sir.
You understand that?
Yes, sir.
Is there anything you need to speak to Mr. Armstrong about before we go any further?
No, sir.
Have any questions about anything I've explained here to you today?
No, sir.
Then is it your decision, Mr. Dryden, to withdraw your not guilty plea, plead guilty to the charge pursuant to the agreement that's in writing that we just went over?
Yes, sir.
And you are a U.S. citizen, right?
Yes, sir.
Okay, right? Then, as to the plea, as to the charge, which alleges that on or about May 7, 2019, in Highland County, Ohio, you did receive, retain, or dispose of certain property being a motor vehicle as defined in ORC Section 4501.01, property of another Alicia Halverson, and that you do at reasonable cause believe you've been paid for commission of theft offense in violation of Section 2913.51 of the Ohio Revised Code, charged with receiving stolen property, a fourth-degree felony, carrying possible sentence between 6 and 18 months, and a fine of $5,000. How do you plead?
Guilty.
All right, thank you. Be seated. All right, the court finds that on this day in open court, defendant was advised of all his constitutional rights and made a knowing and intelligent voluntary waiver of the same pursuant to Article 11. Please accept the order filed. Defendant is not found guilty, but instead the court pursuant to 2935.36 of the Ohio Revised Code and the conditions of the program previously approved by the court finds there's nothing that renders this defendant ineligible to participate in the diversion program. Therefore, his request to be admitted into that program is granted. There will be no finding of guilt at this time. The guilty plea will be held in advance, pending the report from the prosecutor's office as to the defendant's progress in the program. It's ordered the defendant pay the court costs, of course, the terms of the agreement, and the court again finds he had to pay his participation fee. They'll also pay any other fees that might be necessary for any programming that he must undergo as a part of this diversion. And the officer investigating the case was also notified.
Yes, Your Honor.
Anything further, counsel? All right, Mr. Dryden, I see Mr. Arzim over here. You're no longer under pretrial supervision, house arrest. That's all gone now. All the new conditions which he'll go over with you, and you'll get a copy of that, and it'll all be explained to you. All right, thank you.
Thank you.
All right, 3 o'clock, Mr. Campbell.
Yes, Your Honor.
Version. Zoom.
Pre-trial.
Yeah. camera's not working for some reason. It says it is, but it's not, obviously. So, this Judge Foss, and you are, Andrew Hill?
Yes, Your Honor.
All right. This is case number 20 CR 37, State of Ohio versus Andrew Scott Hill. This hearing is being conducted by Zoom. Mr. Hill is at, Monday program in Dayton, is that correct?
Yes, Your Honor.
All right. And his attorney is Catherine Hackner, appearing from her office by Zoom, and then prosecuting attorney Collins from her office. And for the record, my screen is blank, but I'm definitely here and malfunctioning. Defendant charged with tampering with evidence and aggravated possession of methamphetamine is the first pretrial, final pretrial set for the 22nd of September. Trial date is set for October 14th. Let's see here. Did you request any discovery yet, Ms. Hackner? I don't see it in the file.
She did, and we've complied.
I thought that was done.
She requested on August the 10th, and we replied on August 11th. We've also provided a bill of particulars, and she's complied back with discovery.
Okay, well, none of that is in the file.
And I did receive a written plea offer also.
Okay, all right. And do you anticipate any pretrial motions?
Not at this time.
Okay. All right. And is your client aware of that plea offer yet?
I have not yet communicated that to him, but I will get that done before the week.
All right. All right. Any other matters you need to discuss at this time?
Nothing I'm aware of, Your Honor.
Okay. All right. Your next hearing will be in person, Mr. Hill, and I think you have that and your assignment notice. And stay in touch with your attorney then. All right.
Is the next pretrial on the 23rd of September?
Let me look here.
That's that jury trial day.
No, 23rd.
Yeah, we have like 12 jury trials set that day.
Well, we'll work around it. We'll figure it out. Okay, thank you. All right, let's shut this over down and restart it and see if that works then. If not, I'll tip. And I'll just have to do the future ones from the. Now go.
I don't know what Marcia was going to do next week. Next Wednesday is 30 some, I think.
Yeah. Well, we gotta have it fixed for next week.
Yeah,
I can't figure out what it is, because, you know, the video shows it's working. When I hit stop video, then it popped up on my filter screen, you know, this is courthouse. Well, updates. Working on updates, 30% complete.
all the cables are tight on the side of
I
it.
just had that, we just used it, the last one we had was on the 20th. You know, and I rebooted it.
Yeah, Friday.
It should have, I don't know why it didn't update then. Here we go, now we're restarting.